Hello, welcome to my Caravan Park Q&A. Now, just to put this into context, I've done 2 live streams already. Most of you watching would have seen them already. The first live stream went over lots of information, lots of issues to do with caravan parks. We ran out of time and therefore it went on to a second live stream. Now, during these 2 live streams, there were many questions that viewers were asking me on the live chat facility. I've also had many emails, messages through my website, theconsumerlawyer.blog as well, all with questions about caravan parks, all to do with problems that you're having. And I promised during both live streams that I would collate all of these questions together and create this video to answer them. Now, what I've done, I've looked at all the questions. There were many of them, and you'll appreciate that lots of these questions were actually the same, or they were asking about the same subject, just worded in a different way. So I've collated the questions together. I've grouped them together into categories, and where more than one person's asked the same question, I put it into one question. So I answer the same for everybody, hopefully. And I've created this video in order to provide you with the answers. Now, there may well be questions that you have that I've not answered, either because you didn't send the question to me, or perhaps because I missed it. There's been so many. Or perhaps you did ask the question, but I misunderstood the reason why you were asking it or the context of your question. If that's you, please do get in contact with me through the consumerlawyer.blog website. Ask me the question and I will deal with it. But hopefully, I think this video, when you put it together with the 2 live streams, answers all of the queries that you as caravan or static caravan owners have had and currently have in relation to the nightmare time that I know many of you are having with park owners. Now, before I launch into the answers to the questions, let me just say this. I am busy producing an amended license agreement to submit to the BHHPA and to other parks that are not members of the BHHPA as well. So we can try and make sure this gets attention from everybody and changes everywhere. I'm also writing effectively a legal advice on what's wrong at the moment, what needs to happen so that you have a fair deal and so that all of your consumer rights are upheld. And so you don't have to go to court, because that's what you don't want to be doing. So that is coming. It's been a very lengthy process because I've had to look at evidence from many people. I've looked at every single message that you've sent. I've looked at it, but it's taken me a huge amount of time to get through all of them. But I felt that's been important to make sure that I have a full understanding, a good grasp of all the facts, all the issues in this matter. So let's launch into this. As I say, I've done it in sections. Here we go. Here's the answers to your questions. Can a park inflate the price of a used van? Now, I have to answer this question in 2 stages because there is, of course, the question comes from people who are saying, I'm buying a used van from a park. Can they inflate the price? Very short answer, yes, they can, because they're selling it. A seller can always inflate a price of any goods, so long as you're aware what the price is and so long as you're aware what all the goods are about. So in this case, you're aware what the caravan is. If they accurately describe that caravan, they can charge what they want. Why is that? Because you have the ability to say, no, I don't want to buy it. Now, the other side of the coin is, can they inflate the price when you, as the seller, are obligated to use the park to sell your van? And some of you have been telling me that's your position. The answer to that question is potentially no, because what may happen, and I've heard this on many occasions, is the park may be thinking, well, I know what I'll do. Mr. Smith wants to sell his van. He says he wants 10,000 for it. We want to sell new vans on this site, or we want to sell other vans that we own and are used. And when I say we, I mean the royal we, the park owner. We want to sell our own van. So yes, we need to manage this sale, but what we'll do, we'll inflate it to 15,000, so no one's interested in that. They'll buy our van. That's not going to be allowed. So those people that ask me this question, if you asked for that reason, i.e., can the park owner inflate the price of your van for third parties and therefore put them off buying? No, that would be an unfair practice. That would be breach of consumer rules. And you could go back and say, That's not acceptable. Now, if you are in this situation, my advice is to get an independent expert stroke valuer to look at your van to give an independent value on it. If they say, in my Mr. Smith example, no, that van's worth £10,000, not £15,000, that means you can legitimately go back and say, actually, I'm not accepting this inflated price. I just want to get it sold. If you're not going to sell it for 10,000, then you're in breach of contract. I'll sell it on my own. You are entitled to do that. Unfortunately, and I should say this is a warning, you may have to get a judge to confirm that. You may have to go to court. But if it's a difference between getting a sale or not, you may be prepared to do that. Now, if any of you are in this situation, please get in contact, because I will provide you some precedent letters, court templates to assist you with it, because it could be tricky. But I'm doing this because you should not be in this situation, and I want to make sure you're not. Hopefully that answers that question for you. Is it right that finance agreements are put through as car loans? Do I really need to answer that question? Because of course the answer is no, but let's clarify the question first, sorry. If you mean that they are, this is the parks, are describing the asset, which is your van, as a vehicle, so it's a car loan, then of course that can't be right. In fact, it will be illegal, it'll be a criminal offence. So if that's what you mean, the answer is no. If you mean they're pushing it through to companies that normally finance vehicles, that will be okay, because many of these companies do also finance static caravans and tourer caravans as well, and they use it as part of their same product that they sell for car loans. So I need a bit more clarification on this question, but if I've answered it, great. If anyone else had the question and I've not really answered it because your question was slightly different, do get in touch. The park falsified information on the finance agreement. This is just like the last agreement. Is it okay? Of course it's not okay. It's a criminal offence. Here's the problem. If you knew the park was doing this, so let's look at some examples. Perhaps they said the van was not as old as it really was, or in a better condition than it really was, or the sale price of the deposit wasn't quite what reality was, or perhaps they inflated your salary on there, or your job description, or anything at all. This is fraud. You cannot obtain a loan with information that's not correct. Now, you have been asking me the question that in relation to park owners. Quite rightly, you've been saying, this is what park owners are doing. I believe this because too many people have told me. But here's the real issue. If you know about it, and you knew about it before the finance went through, you're a party to what effectively is a fraud. So if you've not got a finance agreement, you're thinking of getting one, you see that this practice happens, just say no and walk away and report them. If it's happened to you already and you did know and you're now concerned, please message me privately so we can see what we can do about this, because it's a serious matter. But let me come back to the short answer to this very easy question. No, no way can you ever, or can a park owner, falsify information. It's wrong, it's illegal, and it's not a good show for park owners. What's the difference between a fixed and a yearly contract? Many people actually have been asking me this question. I think the reason for this is that I know lots of parks had you on fixed contracts for a period of time, and now they're trying to convince you at the end of the term that you should not move on to another fixed term contract, maybe 5 years, 10 years, whatever it is, but you should move to a yearly contract. So let me divide this question into two. The first answer is, what's the difference? Well, the difference is simple. With a fixed term contract, there is a fixed number of years. It'll be 2, 5, 10, 15, sometimes 20, but it's unusual, years where that contract will continue until the end of the term, unless one of the parties has the right to terminate. Now, this contract gives you lots of security because it means that the park can't go to change terms on you during the fixed term period unless there's agreement to do so, such as increasing the annual pitch fee. which you know I'm very passionate about, and I think they're doing it wrong anyway. But that's the basis of it. They can't really come along and kick you off unless you're in breach of contract. A yearly contract is different, because unless they've promised you at the start that they will auto renew that agreement, the terms won't change. Unless they've done that, it basically means that at the end of the term, it's a renegotiation. Everything's back up in the air again. So they can say to you, well, actually, we're moving you. We don't want you there. We're going to move to the pitch over there with not a sea view, but a view of a tree. Or the pitch fee's going up by a huge amount, or something else like this. They can do all these things because it's a renegotiation. So the second part of the question, remember I divided it into two. The second part is what you should be asking me. If I'm asked or told by the park owner that they want to move me to a yearly contract, should I say yes? Answer, no. You should always go for a fixed term contract because it gives you far more security. And the way that I'm going to change, I'm calling these contracts, but really they're license agreements. The way I'm changing the template license agreement and the way I'm encouraging the park owners to change the agreement is to be more fair to you. So we don't have this kind of practice which is detrimental to consumers. And this new change, this new agreement that I'm hoping they'll adopt, works better for you if it's a fixed term contract and not a yearly contract. I hope that answers the question. Should parks be using 12 months agreements so they can make changes annually without consent? This actually is the same question as before. So basically what you're asking me is it really allowed? Is it fair that parks move you to a 12-month contract so they can renegotiate all the terms? Answer again, no, it's not fair, of course. You shouldn't go with it. You shouldn't be tricked into this. I've heard from some of you telling me that park owners have told you that you're better off being on this yearly contract. It means it's more flexible for both parties. You really, Mr. Smith, you should sign it. No, no, no. All of those reasons are wrong. You are better off being in a fixed term contract unless you are someone that wants the flexibility of being able to move in the next 12 months, because you may well change your mind about the site. You don't want to be pinned down to this particular site. To be honest, I've spoken to many of you now, whether it be on the phone, email, whatever it is, and I don't think many of you are in that situation. You want security. That means you want a fixed term contract, not an annual contract, not a yearly contract, which is the same thing with a different name. Our park charges £7.89 for a £5 electric token. Many variations of this question has come through to me, different numbers, but you can see the concept of the question, and it really is, can a park owner inflate electricity charges or any types of utility charges? Can they put a profit on top? The answer is yes, they can. There are regulations that monitor this and regulate this, so they can only go so far. That question, scenario in that question would be okay. If they came along and said, we're selling you £5 of electricity and you're going to pay us £15, that would not be okay. So what I'm going to do to make this easier, I'm going to post on the consumerlawyer.blog, my website, a chart that shows you what they can and can't do with utility, with energy costs. So that's gas, if you're on mains gas rather than the bottles, I think most are on bottles, or electricity or water. So I'll post that on there so you can see. So conceptually, yes, they can inflate the price, but there's only so far they can go. What about if the park rents its own vans as well? Is this not a conflict? Now, to put this into context, this question comes from people who are saying, we rent our caravan out, but our park owner makes us do the rental through them. So they facilitate the rental to the person who rents. Now, that is okay, so long as they're being fair. But if they've got a situation where they rent their own vans and yours, the park owner has to be careful to be fair to you, because they are in a competitive situation. So if they favour their own bookings over yours, that's unfair. That will be a breach of contract. Now, with a contract, we have what's called express and implied terms. Express terms are those that are written in the contract, typed in the contract in your situation. So if it says it in the clause, in the contract, sorry, it's an express term. An implied term is an unwritten term, an unwritten rule. So let me give an example of that. The Consumer Rights Act provides that goods must be fit for purpose, of satisfactory quality, and as described. Now, you don't have a contract with a retailer that says the sofa is going to be as described. But what happens is the law, the Consumer Rights Act, says these terms are implied into every single contract where you sell goods to consumers. Now, if I apply this here, there is an implied term that you'll be treated fairly, and there is an implied term that the park will not compete with you in relation to rentals, where you have an obligation to let them facilitate the rental situation. So if you've got proof that they are favouring their own rentals over yours, and you are being detrimented by this, as obviously you would be, then you can go back and say, that's a breach of contract. I'm going to rent it out myself without your involvement. Can parks put disconnection fees up from £350 to £750 in 1 year? Forget the numbers. The question really is, can they put disconnection charges up that much? Again, let's put the question into context. So what you're asking me is that if we're going to move, we know we have to go back to the park and allow them to do all of the disconnection services, whatever they are. And we have to pay them for it. But do we have to give them whatever money they want? And can they increase that amount year on year? Now, the answer to this question, you remember if you watched me on the live stream, I kept making a big deal of what you were told pre-contract. So pre-contract, did they make clear that you were going to have to pay disconnection charges? You were going to have to use their services for this when you move. Is there a clause in the contract that provides for this? If the answer is yes, it means they can charge that. They can make you use their services. Next question, does the contract, or did they explain to you, does it say that we can, as in the park owner, increase the price of that every year? If the answer is yes, does it say by how much? Because what you as a consumer do not have to do, you do not have to enter into an open-ended contract where you have no idea how terms are going to change. If I put this into context with this question, that means you don't have to play the lottery and wonder, how much are they going to put it up by? When I opened the contract, it was £350. A year later, as in this question, it's £750. No, unless they put you on notice of that, unless you knew, your eyes were wide open when you entered the contract on this point, then the answer to this question is no, they cannot do that. We were given a refund last year as a credit against this year's fees. This is pitch fees that this is talking about. But this was on the proviso that they are not liable for further lockdowns. Let's put it into perspective. What you're telling me, or some of you are telling me, is that park owners last year gave in. I think I was a big part of that because I was bashing some of the park owners on this point. They gave in and they said, yes, we're going to give you a reduction in your pitch fees, recognizing quite rightly that you've not had all of the services you paid for. But there is a condition that if we go into a lockdown next year, i.e. 2021, we're not going to give you another reduction. This is a one-time reduction. And you're asking me, is that lawful? Is that okay? Or should they not have said that? The answer to the question is, it was lawful for them to put that to you, but every time there's a lockdown, you have the right to go back and say, I'm now not getting the services again. So the reduction you've had will be for a certain period of time. And if we then went into a further lockdown, as we know we did, and now you're not getting services again that you've paid for again this time, then you're entitled to go back again and say, actually, that condition you put on me last year, that wasn't lawful. You now need to give me the reduction again. I'm very clear on this point. If you pay for goods or services, in this case services, and you do not receive them, or all of them as you're entitled to and as you've paid for, you're going to be entitled to a refund, either a full refund or more likely in your scenario, a partial refund for things like security, grass cutting, removing of rubbish, anything else that they've not been able to do, you can get a refund for. So again, to come back to the question with a very short answer, can they do this? No, they can't bind you last year to lockdowns this year. That's just not right. We paid for site fees with a credit card, thinking it would give us some protection against refunds, etc. We had a full refund, i.e. a Section 75 refund that will be, but now we've received a letter to say we have 7 days to pay it back. I think what you probably mean is you've received a letter to say that the credit card company is going to debit your account in 7 days with this because they're overturning their decision. Again, let's put it into perspective. This is what we call a Section 75 claim. Now, when you pay on a credit card, if something goes wrong, you can make what's called a chargeback claim if you're within 120 days of purchase, or in this case, of when you paid for the pitch fees. I know most of you are not in that situation, so probably that's not the way to go. Or you can make what's called a Section 75 claim. Now, anyone that watches me or listens to me on LBC regularly will know this is one of my hot topics. I like this topic because it gives me loads and loads of protection. So if you pay on a credit card, something goes wrong, you can make the credit card company, the card provider, step into your shoes, give your money back, and in this case, take the fight up with the park. Here's the problem. When they take the fight up with the park, if the park comes back with some weird and wonderful, or perhaps sensible legal argument, sometimes the card provider will say, okay, we accept this argument, Mr. in this case, park owner. We're going to agree with you, go back to the van owner and reverse our decision. So the question is, can that be done? Yes is the answer, unfortunately, but there's some good news because many people tell me this happens to them, not just with pitch fees, but purchase of goods and services elsewhere. Many people tell me this happens. And usually we find when we look at what the trader, in this case, the park owner, has told the credit card company, the card provider, normally it's wrong. Normally they've pulled the wool over the eyes of the card provider. And when we go back and argue the point, they re-reverse it again in your favor. The fact of the matter is these park owners had a contractual obligation to provide you with all of the services that you pay your pitch or your site fees for. If they were unable to do that because of the lockdown, which is the case here, there is a breach of contract because they've not given you what you're entitled to. That means you're entitled to the money back, and that passes the test, if I put it in its simplest terms, under Section 75. If I put some law to this, it's the Consumer Credit Act 1974. Been around a long time, and many people don't know about it. So let's come back to the question. Short answer, yes, they can reverse the decision, but don't worry, because often if you go back, ask why they've done it, argue the point, often they'll reverse it again. What percentage refund are we entitled to? That is the $1 million question that I can't really answer generically because it will depend on your particular circumstances, your particular case. So what do I mean by that? Well, what I mean is how much do you pay for security, if at all? How much do you pay for rubbish collection? How much do you pay for grass cutting? What other services are included in your pitch or site fees? And what services were actually provided? So whilst you were in lockdown and you couldn't go on the site, did the park still provide security? If the answer is yes, well, they've done what they said. You can't ask for a refund there. Were they still cutting the grass? If they did, well, again, they did what they said. Were they still removing rubbish? You get where I'm going with this. Were they doing all of the services? So with some of you will be able to say, yes, they were. Some will say, no, they weren't. And there'll be a little bit in between. This is why this question cannot be answered generically. It's dangerous when people do answer that question generically. They do. Over the internet, consumer apparent experts do answer it in that way. You won't get that from me because it's not possible. You are entitled to a refund in relation to what you did not get. So what you need to do is ask the park for a breakdown. I know they're going to refuse that breakdown. My view is you're entitled to it. If you're paying for something, you as a consumer are entitled to know what you're paying for and how it's apportioned. And that's what you need to do. If you paid by credit card and the park won't give you a breakdown, that's a reason to go back to the card provider and say, I've got a dispute. I want some of my money back. Then you'll find they'll go and argue it with the park, and the park will probably give them a breakdown. But ultimately, in my view, my firm view, the law sits on your side in this area. I've actually written about this a great deal on my website, theconsumerlawyer.blog. So I won't say too much more about it now. Go to the blog, have a look and see what I've said. It's about Park Dean in particular. See all the advice there. They, in many occasions, did the right thing, actually. I'm hoping they continue to do the right thing. I'm not sure they are. But read that and it'll give you all of the information that you need to know if you want to go and claim a reduction in your site fees. Let me finish this question by saying this. You're not entitled to a full reduction. I've not seen one case yet where I thought you are, but you're definitely entitled to a partial reduction. And in some cases, it's quite a lot of money.